Yeah, what's up, kings and queens? What's up? We live, guys. Let's talk about today's proceedings. Let's talk about the granted application for the defense when they were trying to get the application for accused number 3 to go and do a dental examination with an independent dental examiner. Now, it's amazing how the state will want to block this kind of application. In fact, they wanted to block it, but you wonder why? Why? Like, aren't you trying to prove that this guy had a gold tooth? And then the argument that was brought in by Mr. Sibanda, in fact, Mr. Mnisi, Mr. Ramosepe, and Mr. Ngumalo, there's nothing that the state could have said that could have prevented the judge to come up with such a ruling, because the state relied on the old playbook, Hepworth versus Hepworth. This is what they were using. This is what they decided, no, I'm going to use this old as ruling that I don't think it was made during the constitution, the current constitution that we are holding. I don't think so. So guys, please like and subscribe. Hit that notification bell so that when we drop more content like this, you are in the loop. Now, it's a bit of a problem because the state couldn't put a concrete argument, concrete presentation on the table. They couldn't. What they gave us was just a piecemeal. Like, I don't understand if they say this knowledge that accused number 3 has about this gold tooth, whether he has it or not, his deniability. It's common knowledge. He can use it when he argue his case and or when he cross-examine. But you ask yourself, why didn't you, the state, do due diligence, like get the required test for, as you did for accused number 1, get the required tests. But everything that the state does is always on some, crooked wave kind of thing. So how's it, Secha? What's up, Queen? How are you doing, Queen? Greetings, and then please, everybody who's on the live, I see there's about 5 now people. Please like the live. Give me those 5 likes, please, guys. Let's continue. I'm gonna share a little clip of Sibanda, giving us his cross-examination, right? In fact, his presentation. What am I saying? His presentation, trying to argue that in fact, the defense shouldn't get that application. It's amazing, right? The things that the state doesn't want to do, that are very easy, that are very achievable, that the state could do, but they don't want to do that because they feel like they want to take this ambush approach, do something that the defense is not thinking about, that the defense is not prepared for. They want to take them by surprise all the time. There's no way that the state ever played their cards open. They're always thinking of tricking the defense. As you can see here, let's just listen to this paltry argument, this very flimsy argument by Mr. Sibanda, right? Trying to convince us that no, the state mustn't be awarded, in fact, the defense mustn't be awarded that application to go and test that guy. And it's surprising that in their argument, they want to now twist the words of the defense and say, no, the defense, Mr. Munisi and Mr. Ramosepe, said some things that they didn't say, admitted some things that they didn't admit. This is what they always do. The last time he did that, Mr. Sibanda, distorting Mr. Ramosepede's admission of the photos. Now, this time, Mr. Munisi stood up. But anyway, let's just hear what he has to say. It's not me, guys. It's the network. It's the feed as it comes from SABC. It's not me. But I think it will get better. It will get better.
Information that might be useful to defense and discovering criminal cases must always be a compromise. In State versus Sheikh 2007, ZACC on page 19, also reported 2008, volume 2 SA, page 208, Constitutional Court on paragraph 43, the court held that fairness is not a one-way street conferring an unlimited right to an accused to demand the most favorable possible treatment, but also requires fairness to the public as represented by the state. This does not mean that accused rights should be subordinated to the public's interest in the protection and suppression of crime. However, the purpose of the fair trial provision is not to make it impracticable to conduct prosecution. See also Key versus Attorney Provincial Division in another 1996, ZACC on page 25, also reported in 1996, volume 4 SA 187, it was the decision of the Constitutional Court, paragraph 13. Then paragraph 4 with you the legal position regarding the cross-examination of Sergeant Mamas. Paragraph 4.1, Section 166, subsection 1 of the Criminal Procedure Act creates the right for the accused to cross-examine any witness called on behalf of the prosecution at the criminal proceedings. Cross-examination is therefore one of the essential components of the adversarial system of procedure. The purpose of cross-examination is to elicit evidence favorable to the party cross-examination.
Now, if you can just summarize, like just go over his points, his talking points, you can just tell that it's not facing directly the issue of why he wants the defense not to be allowed that application. It's just getting around. It's getting around, like he's talking about cross-examination. When they're talking about for us to conduct a fair cross-examination, we need to have that examination done because it will afford us a chance to ask this guy, since you decided to bring this guy as a what you call a facial expert, as even though Ratha said anybody can see what they see and then become a good judge of that. You try to make this guy, Mr. Mabaz, a facial expert, even though he was just a compiler of a CD, right, of that memory card. Now, he had to be a facial expert witness and something like that. Now, Sibanda is getting around the issue. He doesn't want to admit that they really ambushed the defense. What they did was bring this evidence when SS Munisi put it. They had this evidence for years, for ages. But they decided no. The only right time that they can produce these photos is after Mr. Munisi was given that chance to go in and go over the court records in order to be able to represent accused number one. Now, it's a problem because you ask yourself, since in the first place, that witness, those witnesses who were in the house, the people who brought the story of the gold tooth and then whoever, the guy who said gold tooth, right, is said to have passed away. But now the version of Zandi, the version of, you remember they pointed out accused number 2 in court. So where do we head? Like, where is the state headed? Because now we were thinking that they are saying accused number 2 is the one who's suspected by the people in the house to be the trigger puller, and then he's the one with the gold teeth. Hence, they took him to the dentist. He's the first one who the state took him there without even being requested. So now they've changed their tune now. Accused number 3 is the one who's now being suspected to have a gold tooth. And it's a photo that, if you look at it, you can see that there's no gold tooth that is being showed on that photo. There's no gold tooth. It's just the story that the state is making up. Anyway, guys, let me just give you a little bit of this clip, and then I'm gonna close out because I really got some other things I have to do behind the scenes. Let's go.
Cross-examining or to challenge the truth. Page 4, or accuracy of evidence given by the opposing party. Per the court in State versus Mgudu, 2008, volume 1, South African Criminal Reports, and page 71 at paragraph 76. G.
Don't forget to drop us a like, guys. Please like the live. Please like the live. Please like the live. See 15 people there, not even a single like. So, guys, come on. What's going on? Come on, do that thing. Do that thing. Do that thing, please. Like the live, guys.
Paragraph 5, the state issued the explanation as to why the examination by the dentist is required for purposes of cross-examination. No reasons have been furnished as to why the examination by a state and a private dentist is necessary. It is difficult to determine whether the request is frivolous or not, or part of deliberate delaying tactic designed to secure the party concerned some unfair advantage over the opponent. No version has been put to Sergeant Mabaso as to whether the accused number 3 has had a gold tooth or not.
So that's the thing. They wanted the defense to trap themselves by deducing a version, like proffering a version that I don't have a gold tooth or I have. But I think the best representative, the best lawyer, the best explainer is that examination. A certificate from a dental examiner and his testimony on the stand. I think that's what will make it. So anyway, guys, I'm not going to take too much of your time. This was what I wanted to pick up on. We're happy that the judge has offered his blessings over the application. Now it's on the defense to go and get, I think, about 3. In fact, my idea, let me just give you my idea before what I tell you what the state is supposed to do. The state is supposed to probably go and get those people. But now, my idea was they must get 3 independent lawyers' quotes. And then from that, they can make a selection from the cheapest one. And then that guy can be paid by the state to be able to conduct that examination. So the state might come with a story that the funds, blah, blah, blah. We'll see. Let's just wait and hear what the state will bring to us. So, guys, let me go bounce. Please like and subscribe. Hit that notification bell so that when we drop more content like this, you are in the loop. Peace. We out.